This entire impeachment process is about the House manager's insistence that they are able to read everybody's thoughts, they can read everybody's intention, even when the principal speakers, the witnesses themselves, insist that those interpretations are wrong. Manager Schiff, Managers Garcia and Dennings relied heavily on selected clips from Ambassador Sondland's testimony. I am not going to replay those. My colleague, Mr. Papura, played those for you. It's clear. We're not going to play the same clips 7 times. He said it. You saw it. That's the evidence. Ms. Lofgren said that, numerous witnesses testified, and this is a quote, that they were not provided with any reason for why the hold was lifted on September 11th, again suggesting that the president's reason for the hold, Ukrainian corruption and burden sharing, were somehow created after the fact. But again, as my colleague just showed you, burden sharing was raised in the transcript itself. Mr. Schiff stated here that just like the implementation of the hold, President Trump provided no reason for the release. This also is wrong. In their testimony, Ambassadors Volker and Sondland said that the president raised his concerns about Ukrainian corruption in the May 23, 2019 meeting with the Ukraine delegation. Deputy Defense Secretary Laura Kraft testified that she received an email in June of 2019 listing follow-ups from a meeting between the Secretary of Defense Chief of Staff and the President relating specifically to Ukrainian security assistance, including asking about what other countries are contributing. Burden sharing. That could be found in Laura Cooper's deposition, pages 33 and 34. The President mentioned both corruption and burden sharing to Senator Johnson, as you already heard. It's also important to note that, as Ambassador David Hale testified, that foreign aid generally was undergoing a review in 2019. From page 84 of his November 6, 2019 testimony, he said the administration did not want to take a sort of business-as-usual approach to foreign assistance, a feeling that once a country has received a certain assistance package, it's something that continues forever. They didn't talk about that in the 23-hour presentation. Dr. Fiona Hill confirmed this review and testified on November 21, 2019. I'm again, quote from page 75 of her testimony, that, quote, there had been a directive for a whole-scale review of our foreign policy assistance, and the ties between our foreign policy objectives and that assistance. This had been going on actually for many months. So multiple witnesses testified that the president had long-standing concerns and specific concerns about Ukraine. The House managers understandably ignore the testimony that took place before their own committees. In her testimony of October 14, 2019, Dr. Hill testified at pages 118 and 119 of her transcript that she thinks the president has actually quite publicly said that he was very skeptical about corruption in Ukraine. And then she said, again in her testimony, and in fact, he's not alone, because everyone has expressed great concerns about corruption in Ukraine. Similarly, Ambassador Yovanovitch testified that they all had concerns about corruption in Ukraine, and as noted on pages 142 of her deposition transcript, when asked what she knew about the president's deep-rooted skepticism about Ukraine's business environment, she answered that President Trump delivered an anti-corruption message to former Ukrainian President Poroshenko in their first meeting in the White House on June 20th, 2017. NSC Senior Director Morrison confirmed on November 19, 2019, at page 63 in his testimony transcript that this was during the Volcker-Morrison public hearing, that he was aware that the president thought Ukraine had a corruption problem, his words again, and he continued, as did many others familiar with Ukraine. And according to her October 30th, 2019 testimony, the special advisor for Ukraine negotiations at the State Department, Catherine Croft, also heard the president raise the issue of corruption directly with then President Poroshenko of Ukraine during a bilateral meeting at the United Nations General Assembly, this time in September of 2017. Special advisor Croft testified she also understood the president's concerns that, quote, Ukraine is corrupt because she has been, this is her words, tasked to write a paper to help then NSA head McMaster's, General McMaster's, make the case to the president in connection with prior security assistance. These concerns were entirely justified. When asked, and again a quote from Dr. Hill's October 14, 2009 hearing transcript. Certainly, these are her words, eliminating corruption in Ukraine was one of, if the central, goals of a foreign policy. Now, does anybody think that one election of one president that ran on a reform platform, who finally gets a majority in their legislative body, that corruption in Ukraine just evaporates? That's like looking at this, and goes back to the Mueller report. You can't look at these issues in a vacuum. Virtually every witness agreed that confronting corruption should be at the forefront of U.S. policy. Now, I think there's some other things we have to understand about timing. This, again, is according to the testimony of Tim Morrison. His testimony. And this is when President Zelensky was first elected. There was real, these are his words, concern about whether he would be a genuine reformer and whether he would genuinely try to root out corruption. It was also, at this time, this was before the election, unclear whether President Zelensky's party would actually be able to get a workable majority. I think we're all glad that they did. To say that that's been tested or determined, that corruption in Ukraine has been removed, the Anti-Corruption Court of Ukraine did not commence its work until September 5th of 2019, 121 days ago, 4 months ago. We're acting as if there was a magic wand, that there was new elections and everything was now fine. I will not, because we're going to hear more about it, get into some of the meetings the vice president had. You'll hear that in the days ahead. Manager Crow said this: what's most interesting to me about this is that President Trump was only interested in Ukraine aid. His words, nobody else. The U.S. provides aids to dozens of countries around the world, lots of partners and allies. He didn't ask about any of them, just Ukraine. I appreciate your service to our country. I really do. I didn't serve in the military, and I appreciate that. But let's get our facts straight. That is what Manager Crow said. Here's what actually happened. President Trump has placed holds on aid a number of times. It would just take basic due diligence to figure this out. In September 2019, the administration announced that it was withholding over $100 million in aid to Afghanistan over concerns about government corruption. In August 2019, President Trump announced that the administration and Seoul were in talks to substantially increase South Korea's burden sharing of the expenses of U.S. military aid support for South Korea. In June, President Trump cut or paused over $550 million in foreign aid to El Salvador, Honduras, and Guatemala because those countries were not fairly sharing the burdens of preventing mass migration to the United States. In June, the administration temporarily paused $105 million in aid to Lebanon. The administration lifted that hold in December, with one official explaining that the administration continually reviews and thoroughly evaluates the effectiveness of all United States foreign assistance to ensure that funds go towards activities that further U.S. foreign policy and also further our national security interest, like any administration would. In September 2018, the administration canceled the $300 million in military aid to Pakistan because it was not meeting its counterterrorism obligations. You didn't hear about any of that from my Democratic colleagues, the House managers. None of that was discussed. Undersecretary Hale, again, his transcript, said that, quote, aid has been withheld from several countries across the globe for various reasons. Dr. Hill similarly explained that there was a freeze put on all kinds of aid. Also, freeze was put on assistance because it was in the process at the time of an awful lot of reviews going on foreign assistance. That's the Hill deposition transcript. She added, this was one of the star witnesses for the managers, she added, this again not played, that in her experience, stops and starts are sometimes common with foreign assistance, and that the Office of Management and Budget holds up dollars all the time, including in the past for dollars going to Ukraine in the past. Similarly, Ambassador Volker affirmed that aid gets held up from time to time for a whole assortment of reasons. Manager Crow told you that the president's Ukraine policy was not strong against Russia, noting that we help our partner fight Russia over there so we don't have to fight Russia here, our friends on the front lines in trenches and with sneakers. And this was following the Russians' invasion of Ukraine in 2014. The United States has stood by Ukraine. Those are your words. While it's true that the United States has stood by Ukraine since the invasion of 2014, only one president since then took a very concrete step. Some of you supported it. And that step included actually providing Ukraine with lethal weapons, including Javelin missiles. That's what President Trump did. Some of you in this very room, some of you managers, actually supported that. Here's what Ambassador Taylor said that you didn't hear in the 23 hours. You didn't hear this. Javelin missiles are serious weapons. They will kill Russian tanks. Ambassador Yovanovitch agreed, stating that Ukraine policy under President Trump actually got stronger than it was under President Obama. There was talks about sanctions. President Trump has also imposed heavy sanctions on Russia for President Zelensky thanked him. The United States has imposed heavy sanctions on Russia. President Zelensky thanked him. Manager Jeffrey said that the idea that Trump cares about corruption is laughable. This is what Dr. Hill said. They didn't play this. Eliminating corruption in Ukraine was one of, if not the central goal, of U.S. foreign policy in Ukraine. Let me say that again. Dr. Hill testified that eliminating corruption in Ukraine was one of, if not the central goal of U.S. foreign policy in Ukraine. If you're taking notes, you can find that at the Hill deposition transcript 34:7 through 13. Dr. Hill also said that she thinks the president has actually quite publicly said that he was very skeptical about corruption in Ukraine. In fact, he's not alone. She said this as well. Everyone has expressed, again, great concerns about corruption. Ambassador Yovanovitch, they didn't play this. She also said we all had concerns. National Security Director Morrison confirmed that, quote, he was aware that the president thought Ukraine had a corruption problem, as did many other people familiar with it. I am not going to continue to go over and over and over again the evidence that they did not put before you, because we would be here for a lot longer than 24 hours. But to say that the President of the United States was not concerned about burden sharing, that he was not concerned about corruption in Ukraine, the facts from their hearing, establish exactly the opposite. The president wasn't concerned about burden sharing. Read all of the records. And then there was Mr. Schiff saying yesterday, maybe we can learn a lot more from our Ukrainian ally. Let me read you what our Ukrainian ally said. President Zelensky, when asked about these allegations of quid pro quo, he said, I think you read everything. I think you read the text. He says, we had a good phone call. These are his words. It was normal. We spoke about many things. I think, and you read it, that nobody pushed me. They think you can read minds. I think you look at the words. I'm going to yield the balance of my time to my colleague, the Deputy White House Counsel, Pat Philbin. He's going to address two issues. So we're going to try to do this in a very systematic way over the days ahead. One involving issues related to, because this came up near the end of there, so I want to do this in a sequence, obstruction as it relates to some of the subpoenas that were issued. He's also going to touch on some of the due process issues, since it was at the end of theirs and fresh in everybody's mind. Mr. Chief Justice.
Mr. Chief Justice, Senators, Majority Leader McConnell, Democratic Leader Schumer, good morning. As Mr. Sekulow said, I'm going to touch on a couple of issues related to obstruction and due process. Just to hit on some points before we go into more detail in the rest of our presentation. I'd like to start with one of the points that Manager Jeffries focused a lot on towards the end of the presentation yesterday, related to the obstruction charge in the second article of impeachment, because he tried to portray a picture of what he called blanket defiance, that there was a response from the Trump administration that was simply, we won't cooperate with anything, we won't give you any documents, we won't do anything, and it was blanket defiance really without explanation, that was all there was just an assertion that we wouldn't cooperate. And he said, and I pulled this from the transcript, that President Trump's objections are not generally rooted in the law and are not legal arguments. And that's simply not true. That's simply not true. In every instance, when there was resistance to a subpoena for a witness or for documents, there was a legal explanation of the justification for it. For example, they focused a lot on an October 8th letter from the counsel to the president, Pat Cipollone, but they didn't show you an October 18th letter, which is up on the screen now, that went through in detail why subpoenas that had been issued by Manager Schiff's committees were invalid, because the House has not authorized your committees to conduct any such inquiry or to subpoena information in furtherance of it. And that was because the House had not taken a vote to authorize the committee to exercise the power of impeachment to issue any compulsory process. And I'm going to get into that issue in just a moment. Not only was there a legal explanation, a specific reason for every resistance, not just blanket defiance, every step that the administration took was supported by an opinion from the Department of Justice, from the Office of Legal Counsel. And those are explained in our brief. And the major opinion from the Office of Legal Counsel is actually attached in our trial memorandum as an appendix. Now, Mr. Jeffries and other managers also suggested that the Trump administration took the approach of no negotiation, blanket refusal, and no attempt to accommodate. That's also not true. In the October 8th letter that Mr. Cipollone sent to Speaker Pelosi, it said explicitly, quote, "If the committees wish to return to the regular order of oversight requests, we stand ready to engage in that process as we have in the past, in a manner consistent with well-established bipartisan constitutional protections and a respect for the separation of powers enshrined in the Constitution," end quote. It was Manager Schiff and his committees that did not want to engage in any accommodation process. We had said that we were willing to explore that. The House managers have also asserted a number of times, this came up on that first long night when we were here until 2 as well, that the Trump administration never asserted executive privilege. Never asserted executive privilege. And I explained at the time, that's technically true, but misleading. Misleading because the rationale on which the subpoenas were resisted never depended on an assertion of executive privilege. Each of the rationales that we have offered, and I'll go into one of them today, that the House subpoenas were not authorized, does not depend on making that formal assertion of executive privilege. It's a different legal rationale. The subpoenas weren't authorized because there was no vote, or the subpoenas were to senior advisors to the president who are immune from congressional compulsion, or the subpoenas were forcing executive branch officials to testify without the presence of agency counsel, which is a separate legal infirmity, again supported by an opinion from the Office of Legal Counsel at the Department of Justice. But let me turn to the specific issue of the invalidity of the subpoenas because they weren't supported by a vote of the House authorizing Manager Schiff's committees to exercise the power of impeachment to issue compulsory process. Manager Jeffries said that there were no Supreme Court precedents suggesting such a requirement, and that every investigation into a presidential impeachment in history has begun without a vote from the House. And those statements simply aren't accurate. There is Supreme Court precedent explaining very clearly the principle that a committee of either House of Congress gets its authority only by a resolution from the parent body. United States versus Rumley and Watkins versus United States make this very clear. And it's common sense. The Constitution assigns the sole power of impeachment to the House of Representatives, to the House, not to any member, not to a subcommittee. And that authority can be delegated to a committee to use only by a vote of the House. It would be the same here in the Senate. The Senate has the sole power to try impeachments. But if there were no rules that had been adopted by the Senate, would you think that the majority leader himself could simply decide that he would have a committee receive evidence, handle that, submit a recommendation to the Senate, and that would be the way that the trial would occur without a vote from the Senate to give authority to that committee? I don't think so. It doesn't make sense. That's not the way the Constitution assigns that authority. And it's the same in the House. Here, there was no vote to authorize a committee to exercise the power of impeachment. And this law has been boiled down by the D.C. Circuit in Exxon Corp versus FTC to explain it this way. To issue a valid subpoena, a committee or subcommittee must conform strictly to the resolution establishing its investigatory powers. There must be a resolution voted on by the parent body to give the committee that power. And the problem here is there is no standing rule, there was no standing authority giving Manager Schiff's committee the authority to use the power of impeachment to issue compulsory process. Rule 10 of the House discusses legislative authority. It doesn't mention impeachment. And that is why in every presidential impeachment in history, the House has initiated the inquiry by voting to give a committee the authority to pursue that inquiry. So contrary to what Manager Jeffries suggested, there has always been, in every presidential impeachment inquiry, a vote from the full House to authorize a committee. And that is the only way the inquiry begins. There were 3 different votes for the impeachment of President Andrew Johnson: in January 1867, in March 1867, and in February 1868. For President Nixon, Chairman Rodino of the House Judiciary Committee explained there was a move to have him issue subpoenas after the Saturday Night Massacre, and they determined that they did not have that authority in the House Judiciary Committee without a vote from the House. And he determined, as he explained, that a resolution has always been passed by the House. It is a necessary step if we are to meet our obligations. There's been reference to investigatory activities starting in the House Judiciary Committee in the Nixon impeachment prior to the vote from the House. But all that the committee was doing was assembling publicly available information and information that had been gathered by other congressional committees. There was never an attempt to issue compulsory process until there had been a vote by the House to give the House Judiciary Committee that authority. Similarly, in the Clinton impeachment, there were 2 votes from the full House to give the House Judiciary Committee authority to proceed. First, a vote on a resolution 525, just to allow the committee to examine the independent counsel report and make recommendations on how to proceed. Then a separate resolution, House Resolution 581, that gave the House Judiciary Committee subpoena authority. And at the time, in a House report, the House Judiciary Committee explained, I'm quoting, "Because the issue of impeachment is of such overwhelming importance, the committee decided that it must receive authorization from the full House before proceeding on any further course of action. Because impeachment is delegated solely to the House of Representatives by the Constitution, the full House of Representatives should be involved in critical decision-making regarding various stages of impeachment." Here, the House Democrats skipped over that step completely. What they had instead was simply a press conference from Speaker Pelosi announcing that she was directing committees to proceed with an impeachment inquiry against the President of the United States. Speaker Pelosi didn't have the authority to delegate the power of the House to those committees on her own. So why does it matter? It matters because the Constitution places that authority in the House and ensures that there is a democratic check on the exercise of that authority, that there will have to be a vote by the full House before there can be a proceeding to start inquiring into impeaching the President of the United States. One of the things that the framers were most concerned about in impeachment was the potential for a partisan impeachment that was being pushed merely by a faction. And a way to ensure a check on that is to require democratic accountability from the full House, to have a vote from the entire House before an inquiry can proceed. That didn't happen here. It was only after 5 weeks of hearings that the House decided to have a vote. And what that meant at the outset was that all of the subpoenas that were issued under the law, the Supreme Court cases I discussed, all of those subpoenas were invalid. And that is what the Trump administration pointed out specifically to the House. That was the reason for not responding to them. Because under long-settled precedent, there had to be a vote from the House to give authority, and the administration would not respond to subpoenas that were invalid. Now, the next point I'd like to touch on briefly has to do with due process, because we've heard from the House managers that they offered the president due process at the House Judiciary Committee. And Manager Nadler described it as that he sent the president a letter, the president's counsel a letter, offering to allow the president to participate. And the president's counsel just refused, as if that was the only exchange. And there was just a blanket refusal to participate. But let me explain what actually happened. And I should note before I get into those details, there was a suggestion also that due process is not required in the House proceeding, that it's simply a privilege. But that wasn't the position that Manager Nadler has taken in the past. In 2016, he said, quote, "The power of impeachment is a solemn responsibility assigned to the House by the Constitution and to this committee by our peers. That responsibility demands a rigorous level of due process." And in the Clinton impeachment in 1998, he explained, "What does due process mean? It means, among other things, the right to confront the witnesses against you, to call your own witnesses, and to have the assistance of counsel." Now, I think we all know that all of those rights were denied to the president in the first two rounds of hearings. The first round of secret hearings in the basement bunker, where Manager Schiff had 3 committees holding hearings, and then in a round of public hearings to take the testimony that had been screened in the basement bunker and have it in a public televised setting, which was totally unprecedented in any presidential impeachment inquiry. In both the Clinton and the Nixon inquiries, for every public hearing, the president was allowed to be present by counsel and cross-examine witnesses. But the House managers say that's all right, because when we got to the third round of hearings, after people had testified twice, then we were going to allow the president to have some due process. But the way that played out was this. First, they scheduled a hearing for December 4th that was going to hear solely from law professors. And by the time they wanted the president to commit whether he would participate, it was unclear. They couldn't specify how many law professors or who the law professors were going to be. And the president's counsel wrote back and declined to participate in that. But at the same time, Manager Nadler had asked what other rights under the House Resolution 660, the rules governing the House inquiry, the president would like to exercise. And the president's counsel wrote back asking specific questions in order to be able to make an informed decision, and asked whether you intend to allow fact witnesses to be called, including the witnesses who had been requested by HIPSI Ranking Member Nunes, whether you intend to allow members of the Judiciary Committee and the President's Counsel the right to cross-examine fact witnesses, and whether your Republican colleagues on the Judiciary Committee will be allowed to call witnesses of their choosing. And Manager Nadler didn't respond to that letter. There wasn't information provided. And we had discussions with the staff on the Judiciary Committee to try to find out what were the plans, what were the hearings going to be like. And the way the week played out, on December 4th, there was the hearing with the law professors, the first hearing before the Judiciary Committee. And on December 5th, the morning of December 5th, Speaker Pelosi announced the conclusion of the entire Judiciary Committee process, because she announced that she was directing Chairman Nadler to draft articles of impeachment. So the conclusion of the whole process was already set. Then, after the close of business on the 5th, we learned from the staff that the committee had no plans other than a hearing on December 9th to hear from staffers who had prepared HPSI committee reports. They had no plans to have other hearings, no plans to hear from fact witnesses, no plans to do any factual investigation. So the president was given a choice of participating in a process that was going to already have the outcome determined. The Speaker had already said articles of impeachment are going to be drafted, and where there were no plans to hear from any fact witnesses. That's not due process. And that's why the president declined to participate in that process, because the Judiciary Committee had already decided they were going to accept an ex parte record developed in Manager Schiff's process, and there was no point in participating in that. So the idea that there was due process offered to the president is simply not accurate. The entire proceedings in the House, from the time of the September 4th press conference until the Judiciary Committee began marking up articles of impeachment on December 11th, lasted 78 days. It's the fastest investigatory process for a presidential impeachment in history. And for 71 days of that process, for 71 days of the hearings and the taking of deposition and hearing testimony, the president was completely locked out. He couldn't be represented by counsel. He couldn't cross-examine witnesses. He couldn't present evidence. He couldn't present witnesses for 71 of the 78 days. That's not due process. And it goes to a point that Mr. Cipollone raised earlier. Why would you have a process like that? What does that tell you about the process? As we've pointed out a couple of times, cross-examination in our legal system is regarded as the greatest legal engine ever invented for the discovery of truth. It's essential. The Supreme Court has said in Goldberg versus Kelly, for any determination that's important, that requires determining facts, cross-examination has been one of the keys for due process. Why did they design a mechanism here where the president was locked out and denied the ability to cross-examine witnesses? It's because they weren't really interested in getting at the facts and the truth. They had a timetable to meet. They wanted to have impeachment done by Christmas, and that's what they were striving to do. Now, as a slight shift in gears, I want to touch on one last point before I yield to one of my colleagues, and that relates to the whistleblower. The whistleblower who we haven't heard that much about, who started all of this. The whistleblower, we know from a letter that the Inspector General of the intelligence community sent that he thought that the whistleblower had political bias. We don't know exactly what the political bias was because the Inspector General testified in the House committees in an executive session, and that transcript is still secret. It wasn't transmitted up to the House Judiciary Committee. We haven't seen it. We don't know what's in it. We don't know what he was asked and what he revealed about the whistleblower. Now, you would think that before going forward with an impeachment proceeding against the President of the United States, that you would want to find out something about the complainant that had started all of it. Because motivations, bias, reasons for wanting to bring this complaint could be relevant, but there wasn't any inquiry into that. Recent reports, public reports, suggest that potentially the whistleblower was an intelligence community staffer who worked with then Vice President Biden on Ukraine matters, which, if true, would suggest an even greater reason for wanting to know about potential bias or motive for the whistleblower. And at first, when things started, it seemed like everyone agreed that we should hear from the whistleblower, including Manager Schiff. And I think we have what he said.
But yes, we would love to talk directly with the whistleblower. We'll get the unfiltered testimony of that whistleblower. We don't need the whistleblower.
What changed? At first, Manager Schiff agreed we should hear the unfiltered testimony from the whistleblower. But then he changed his mind. And he suggested that it was because now we had the transcript. But the second clip there was from September 29th, which was 4 days after the transcript had been released. But there was something else that came into play. And that was something that Manager Schiff had said earlier when he was asked about whether he had spoken to the whistleblower.
We have not spoken directly with the whistleblower. We would like to.
And it turned out that that statement was not truthful. Around October 2nd or 3rd, it was exposed that Manager Schiff's staff, at least, had spoken with the whistleblower before the whistleblower filed the complaint and potentially had given some guidance, some sort, to the whistleblower. And after that point, it became critical to shut down any inquiry into the whistleblower. And during the House hearings, of course, Manager Schiff was in charge. He was chairing the hearings. And that creates a real problem from a due process perspective, from a search for truth perspective, because he was an interested fact witness at that point. He had a reason, since he had been caught out saying something that wasn't truthful about that contact. He had a reason to not want that inquiry. And it was he who ensured that there wasn't any inquiry into that. Now, this is relevant here, I think, because as you've heard from my colleagues, a lot of what we've heard over the past 23 hours, over the past 3 days, has been from Chairman Schiff. And he has been telling you things like what's in President Trump's head, what's in President Zelensky's head. It's all his interpretation of the facts and the evidence, trying to pull inferences out of things. And there's another statement that Chairman Schiff made that I think we have on video.
But you admit it's all you have right now is a circumstantial case.
Actually, no, Chuck. I can tell you that the case is more than that, and I can't go into the particulars, but there is more than circumstantial evidence now. So, again, I think...
So you have seen direct evidence of collusion?
I don't want to go into specifics, but I will say that there is evidence that is not circumstantial and is very much worthy of investigation.
So that was in March of 2017, when Chairman Schiff, as ranking member of HIPSI, was telling the public, the American public, that he had more than circumstantial evidence through his position on HIPSI that President Trump's campaign had colluded with Russia. Now, of course, the Mueller report, as Mr. Sekulow pointed out, after $32 million and over 500 search warrants, or roughly 500 search warrants, determined that there was no collusion, that that wasn't true. And we wanted to point these things out simply because, for this reason. Chairman Schiff has made so much of the House's case about the credibility of interpretations that the House managers want to place on not hard evidence, just but on inferences. They want to tell you what President Trump thought. They want to tell you, don't believe what Zelensky said, we can tell you what Zelensky actually thought. Don't believe what the other Ukrainians actually said about not being pressured, we can tell you what they actually thought. That it is very relevant to know whether the assessments of evidence he's presented in the past are accurate. And we would submit that they have not been, and that that is relevant for your consideration. With that, I will yield to my colleague, Mr. Cipollone.
Mr. Chief Justice, members of the Senate, I have good news. Just a few more minutes from us today. But I want to point out a couple of points. Number one, just to follow up on what Mr. Philbin just told you. Do you know who else didn't show up in the Judiciary Committee to answer questions about his report in the way Ken Starr did in the Clinton impeachment? Ken Starr was subjected to cross-examination by the President's counsel. Do you know who didn't show up in the Judiciary Committee? Chairman Schiff. He did not show up. He did not give Chairman Nadler the respect of appearing before his committee and answering questions from his committee. He did send his staff, but why didn't he show up? Another good question you should think about. Now, they've come here today, and they basically said, let's cancel an election over a meeting with Ukraine. And as my colleagues have shown, they failed to give you key facts about the meeting and lots of other evidence that they produced themselves. But let's talk about the meeting. They said it was all about an invitation to a meeting. If you look at the first transcript, the President said to President Zelensky, when you're settled in and ready, I'd like to invite you to the White House. We'll have a lot of things to talk about, but we're with you all the way. And President Zelensky said, well, thank you for the invitation. We accept the invitation and look forward to the visit. Thank you again. Then, President Zelensky got a letter on May 29th, inviting him again to come to the White House. And then, going back to the transcript of the July 25th call, again a part of the call that they didn't talk to you about, President Trump said, whenever you would like to come to the White House, feel free to call. Give us a date, and we'll work that out. I look forward to seeing you. President Zelensky replied, thank you very much. I would be very happy to come and would be happy to meet with you personally and get to know you better. I'm looking forward to our meeting, and I also would like to invite you to visit Ukraine and come to the city of Kyiv, which is a beautiful city. We have a beautiful country which would welcome you. Then he said, on the other hand, I believe on September 1, we will be in Poland. And we can meet in Poland, hopefully. Now, they didn't read you that part of the transcript, and they didn't tell you what happened. A meeting in Poland was scheduled. President Trump was scheduled to go to Poland. He was scheduled to meet with President Zelensky. What happened? President Trump couldn't go to Poland. Why? Because there was a hurricane in the United States, and he thought it would be better for him to stay here to help deal with the hurricane. So the vice president went. Why didn't they tell you that? Why didn't they tell you that President Zelensky suggested, hey, how about we meet in Poland? Why didn't you tell them that that meeting was scheduled and had to be canceled for a hurricane? Why? So that was our first question that we asked you. You heard a lot of facts that they didn't tell you. Facts that are critical. Facts that they know completely collapse their case on the facts. Now, you heard a lot from them. You're not going to hear facts from the president's lawyers. They're not going to talk to you about the facts. That's all we've done today. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? The American people paid a lot of money for those facts. They paid a lot of money for this investigation. And they didn't bother to tell you. Ask yourself why. If they don't want to be fair to the president, at least out of respect for all of you, they should be fair to you. They should tell you these things. And when they don't tell you these things, it means something. So think about that. Impeachment shouldn't be a shell game. They should give you the facts. That's all we have for today. We ask you, out of respect, to think about whether what you've heard would really suggest to anybody anything other that would be completely irresponsible abuse of power to do what they're asking you to do. To stop an election, to interfere in an election, and to remove the President of the United States from the ballot? Let the people decide for themselves. That's what the founders wanted. That's what we should all want. And with that, I thank you for your attention, and I look forward to seeing you on Monday.
The majority leader is recognized.
Mr. Chief Justice, I ask unanimous consent the trial adjourn until 1 p.m. Monday, January 27th, and that this order also constitute the adjournment of the Senate.
Without objection, so ordered. The Senate is adjourned.